All rise.
Good afternoon again. I apologize for the delay. Please be seated. Detective, if you can resume the chair again, please, and Mr. Evans.
May I proceed, Your Honor?
Oh, sure.
Hi, Detective.
Good afternoon, sir.
I draw your attention back to the date in question. You're a Bloomfield Hills detective?
West Bloomfield.
West Bloomfield. You've
Yes,
been
sir.
working in that capacity for 8 years?
I've been working as a police officer for almost 9 years. I've been a detective for almost a year.
A year?
Yes, sir.
Okay. A year today?
No, almost a year.
Almost a year, not quite a year?
No, sir.
Your first homicide?
Yes, sir.
Okay. I'm drawing your attention back when you had some communication with my client, Mr. Smith,
Yes, sir.
in the jail. Was that the Oakland County Jail or was that the West Bloomfield Jail?
West Bloomfield.
Okay, and you said at some point he communicated that he wanted to speak to you?
Yes.
How'd you receive that communication?
In person from Sergeant Spencer.
From Sergeant Spencer?
Yes, sir.
At what time did you receive it?
Approximately 4 p.m.
About 4 p.m.? What time did you arrive to speak with him?
About 4:10,
About
4:15.
4:10. And were you alone or were you with someone else?
Initially, I was alone.
And who assisted you?
When I initially spoke to him?
Yes.
No one.
No. Was it done inside the cell or did you remove him from the cell?
He was inside the cell.
Okay. Were there any civilians around? Or was he isolated?
He was in a cell by himself.
Okay. And at that point, had he been formally charged yet?
No.
Okay. But he was a suspect in the crime, is that correct? Before you began your interrogation, you said you read the Miranda rights
Correct.
to him, correct?
Yes.
You had no prior experience with him, is that correct? You didn't know him before that day.
From that, prior to that case, no.
No, okay. And why'd you read him the Miranda?
Because he was in custody and I was interrogating
You
him.
were interrogating him, okay. Now, this was a video or audio? How did you record that communication?
Both video and audio.
Okay. And you realized that the video was compromised because you can't see anything? You understand? You realize that now, correct?
No.
You were not aware that the video was compromised and you can't see?
No, that didn't happen.
It didn't happen?
No, sir.
Okay. So if I were to tell you that I have a video that does not show the actual footage of the interview, you would be surprised?
I would be very surprised, yes.
Okay. Now, you read him as Miranda. Did you know if he can read or write? Did you know if he can read or write?
No.
Why didn't you ask him?
I didn't think that was necessary.
You didn't think his comprehension was necessary in order for you to have him effectively waive or write? You didn't think his comprehension was relevant?
His reading comprehension, no.
Did you ask him to read the Miranda out loud?
No, I
so
read
that
it
way
to
you
him.
can, excuse me, to confirm whether he understood what you were saying?
I asked him to answer if he understood each right as I read them.
You read them. I'm saying, did you ask him to read it to see if he was comprehending what you were discussing, the right that he was giving up?
Yes, I asked him to say if he understood.
I said, did you ask him to read it? Read the rights that were contained within the Miranda.
I don't recall if I gave him a form of his own to follow along with or if I showed it to him.
Did you ask him if he has a history of learning disability?
No,
Why not?
I don't believe that was relevant.
You don't think it's relevant to see if a person has a history of learning disability before they waive an essential right?
No.
You didn't think that was necessary?
No, sir.
So how do you know if somebody's comprehending if you don't confirm their level of intelligence?
Because
Objection, Your Honor. It's irrelevant how you can tell when someone, if we're talking about the defendant, I think that's
Well,
what his
what
question
about my
should
client?
focus.
Then I could be more specific. How were you convinced that he knew he was giving up an essential right at the time that you were interrogating?
because I asked him if he understood them and he said
But
yes.
if he doesn't comprehend, what good was that going to do you?
He followed along as I read and he
But
said
you
he
read it.
understood.
Why didn't you ask him to read it? You read it. If you wanted to see if he can read and write, and comprehend, wouldn't that be the reasonable thing to do? Is to say, "Read this to me."
No, I don't believe that's the
You
law.
don't think that would be reasonable? Oh, okay. How about did you ask him? Did he have a history of mental health?
No,
You didn't want to know about his mental health history either. You didn't think that played a part in whether he was in a position to waive an essential right without a lawyer?
no.
You say this is your first homicide?
Yes, sir.
It's not your first interrogation.
No.
But that's the policy. You just take the statement regardless whether somebody understands or not.
Objection, Your Honor. It's already been done. So stay.
How long did the interview last?
Believe an hour and a half?
Okay. Did you offering treats or anything like that?
No, I didn't have any on hand.
Okay. Now, you were testifying on direct examination that you discussed with him what allegedly occurred that evening, correct?
2 evenings prior.
Right. Did you get a timeline from him
Yes.
specifically? When you arrived at the house, you said that there were how many officers in the house?
What house are you referring to?
Stringer's house.
At which point?
At your initial investigation, when you first arrived at that home, and they had Jaylen and the police in the kitchen with how many other officers?
In the kitchen or in the home?
In the home first.
Approximately 6.
6 officers. How many were in the kitchen with Jaylen?
2.
2. Okay. 2 and yourself?
I was just outside the kitchen.
And in the course of your investigation, were you made aware that he had a lawyer that was there?
No.
You never knew that Mr. Thomas Thomas Randolph, you didn't see him there?
No.
No one identified him as a lawyer?
No.
You didn't know that Jaylen had been talking to his lawyer before he started talking to you?
I never spoke with Jaylen.
Okay, well, you said you went into the interview room when they were interviewing him in the kitchen, right?
I stood just outside and observed.
Right. And no one, you're the officer in charge, correct?
Correct.
And no one informed you that the lawyer was there and the lawyer had prepped him before he started talking to the police?
No.
Were you there when his father was coaching him to talk to the police?
I was there while his father was speaking to him.
All right. Telling him what to do. Talk to the police. Father told him that, right? You heard it.
I believe I heard him say that, yes.
And in the course of your investigation, were you aware that his father had received information from neighbors about what had occurred before the police arrived?
Objection, Your Honor. Number one, it calls for speculation. It also
That's
calls
part-
for hearsay, and it assumes facts not in evidence.
I'm asking the course of his investigation, he's the officer in charge, was this information that he was made aware of before he began his investigation?
The objection is sustained the way you asked it.
Okay. Did you ever interview the father? Jaylen's father?
Are you talking about that evening?
That evening, yes,
I did
sir.
not.
You never interviewed him?
I did not.
Did he ever volunteer information that he talked with other people about this crime before it occurred, before you
Not to
got
me.
there? Never talked to the officer in charge?
No.
Okay. You're in his house?
Correct.
Okay. And he sat there while he was in the same room with Jaylen while Jaylen spoke to the police, correct?
At some points, yes.
Okay. Was he there or not?
He was in the house, yes.
In the room, in the kitchen?
Objection,
At
Your
some
Honor.
points,
Absent.
yes.
Sustained.
You saw Jaylen that evening?
I did see him, yes.
That morning, correct, right?
Yes.
You remember how he was dressed?
I don't.
You remember if I told you he was dressed in black hoodie, black pants, would you disagree?
I couldn't disagree
You
because I
just
don't
couldn't
recall.
disagree with that? He wasn't in his night clothes, was he?
I don't remember.
You don't remember? What would help refresh your memory? Remember, you seem to know everything else.
Objection, Your Honor.
Sustained.
Okay. What would refresh your memory?
I don't think there's anything that could
You don't
refresh
think
my memory
anything
at this
your
point,
police
sir.
reports won't refresh you, how he was dressed when you came into the house to
No, I don't
investigate?
believe that was documented.
Do you? Okay. So I'm sure you don't remember what Mr. Smith was wearing that evening, do you?
I didn't see Mr. Smith that evening, sir.
Okay. Footprints from the gym shoes. You didn't go out as an evidence tech just to see the footprints, did you?
Correct.
So you were just provided selective footprints, correct? Photos, selective photos that were taken by the evidence tech.
I was provided with all photos taken
I
by the evidence
understand
tech.
that was upon the discretion of the evidence tech, which photos he felt were necessary to proceed forward with this case. Is that correct?
No.
So you did your own had your own observations. You went out there to the boat launch,
I did go to the boat
right?
launch.
And did you see any footprints?
Yes.
How many pairs of footprints did you see?
It appeared there were two.
Just two pair of footprints?
Two sets.
Two sets of footprints.
Correct.
Right? Out at the scene where the car was found. Did you go out there?
I was at that scene, yes.
Did you see any footprints?
Yes.
How many footprints did you see?
Which car are you referring
The
to?
burn car.
The burn car?
Yes, sir.
One.
One set of footprints?
Yes.
When were you out there?
Maybe 3:30, 4 a.m.
Okay. And you were aware that the fire department had been out there. They were out there before you arrived, correct?
Yes.
And they used water to extinguish the car, correct?
Yes.
And that the footprints, that the area immediately around the car was compromised because the water washed any possible evidence away, correct?
I'm aware of that, yes.
Okay. So you don't know if there's more than one set of footprints that were out there or not, is that correct?
Not from the air that was washed away, no.
Now you also made reference to a video where you saw my client, Mr. Smith, and Jaylen Stringer were inside of the Cordova, correct?
Yes, sir.
And you said that they're a pair of black shoes and a pair of blue shoes, correct?
Yes, sir.
And you're making your observations based upon what's in the video, correct?
Correct.
Were they dark blue shoes or light blue shoes?
Dark blue.
Dark blue. Wouldn't you agree with me, dark blue and light blue are similar in color? I mean, strike that. Dark blue and black are similar colors,
They are similar.
right? And so the shoes, from your vantage point, look the same, correct?
The same as what?
The same color. You were able to distinguish between a dark blue shoe and a black shoe?
Objection, asked and answered.
Overruled.
You the prosecutor? I'm just asking.
You can object.
Okay. Ain't doing no good. Excuse me? You were able to differentiate between dark blue shoes and black shoes?
Yes.
Okay. And how long before the alleged incident that occurred, were they at the restaurant? How many hours before?
About 4 hours.
4 hours before?
Yes, sir.
So it's fair to say you don't know who was wearing those shoes at the time of the incident. Is that correct?
Who was wearing which shoes?
The black shoes or the blue shoes? You know, the young men exchange shoes.
Based upon that video, no.
Okay. And the shoes were given to the department from Jaylen, right?
Which shoes?
The black shoes. Jaylen is the last person that had those shoes, isn't it?
Correct.
And he gave them to the police, correct?
Correct.
After he talked to his father, right?
Yes.
Okay. You were asked questions. You remember questions being asked about black gloves?
Mm-hmm.
Were you informed that there was multiple pair of black gloves in that house? Multiple pair of latex gloves in that house, correct?
I was informed that, yes.
Yeah, right. And there was also a marijuana grow operation in the basement.
I was also informed that.
You were aware of that, is that correct? Why didn't you include any of that in your report?
Because I didn't see it.
You didn't see it?
No.
There's a lot of stuff that you didn't see that you included in your report, right?
Yes.
You relied on other officers, correct?
Correct.
And other officers informed you that you know there's multiple black gloves down here, there's a marijuana grow operation down here.
Other officers didn't inform me there were
Well,
black
how
gloves
did you
in the
find out
basement.
about it then?
Your client told me.
Okay. And did you go back to confirm it?
No.
Why?
Don't believe that was necessary.
You didn't think it was necessary?
No.
Okay. At some point, in your opinion, you had formed an opinion that his story wasn't adding up, my client, Mr. Smith, correct?
Correct.
Tell him to come clean?
Not in those words, but yes.
Right. You still say I didn't do it, correct?
I'm sorry?
He said I didn't do it.
He said that, yes.
Did you ask him why he was covering for his friend?
No,
Why not?
because I didn't believe he was covering for his friend.
Okay. Did you ever have an opportunity to question Mr. Stringer?
I did not,
Why not?
because he had already been interviewed by another detective.
Okay. Now, you said that you were in the basement. Were you in the basement? Did you ever go in the basement?
No, sir.
You never went to the wash machine?
I went to the wash machine,
Where's the wash machine?
main floor.
Main floor? And did you ever, you say you looked inside, correct?
Mhm.
And you saw some clothing inside.
Hmm.
And based upon the information you received from Jaylen, he was the person that was using the wash machine, correct?
Yes,
He was washing clothes.
correct.
Was the washing machine retained to test for prints to see if that information was true?
No,
So anything Jaylen told you, as long as he's putting it on him, is truthful. Is that what you're telling us? Anything Jaylen tells you, as long as he's putting it on this young man, is true.
no,
Were you there when the weapon was discovered?
no,
You weren't there?
no.
Were you aware that Jaylen had given 2 or 3 different versions of where that gun was located?
Objection, that's not in evidence.
You have compiled all the information, correct?
Not all of the information,
Right.
no.
How about officer, and I want to make sure I get the name right. Pro skirt, W Broskirtk.
That would be Detective Rochard,
Okay. You read his report, correct?
her report.
Her report.
Yes,
And that's part of your case in chief, correct?
correct.
Okay. And you were, and not for the truthfulness of it, but as a result, I mean, as a way to continue your investigation, you were never made aware that he had given 3 different versions of where the shoes were? Not strike that, where the gun was?
Objection, that's not evidence.
Well, he's asking it a different way now, so overruled, go ahead.
No, I was not told there were 3 locations given.
You didn't know that they had looked in one vent and didn't find the gun? They looked in a second vent, didn't find the gun? And ultimately it was found in a third vent?
No, I was not aware of that.
Your Honor, I would object at this point because it still assumes facts, not in evidence. Because they looked in 3 vents does not necessarily mean they were told it was in a particular vent. So I think he's mischaracterizing what he's prefacing his question.
So are you saying you wouldn't, so my question is this, so you're saying that information is not contained in the officers, detectives, in her report?
I'm not saying that.
You've read the report,
Correct.
right? And you don't recall seeing that information in her report?
No.
How about the numerous empty gas cans that you found in Jaylen's garage?
I didn't find any gas cans. in
You were
Jaylen's garage.
told that there was numerous gas cans that were found, correct?
Correct.
Right. Did you confiscate any of those gas cans? Or have them confiscated and see, had Jaylen been in contact with the gas can?
I did not confiscate any gas
You're the
cans
off-
from the garage.
Where'd you get a gas can from?
From the back of Javon Stringer's truck.
From Jaylen's truck, correct?
Javon Stringer.
Javon Stringer, so
Correct.
that's Jaylen's brother.
Yes, sir.
Was he taken into custody and interrogated, asked questions about what, if any, relationship involvement he may have had to this homicide?
He was asked questions, as far as I know, but he was not taken into custody.
Never took him into custody?
No.
Because at this point in the investigation, at that point, you didn't know who did it. Is that correct?
At which point in the
The
investigation?
point that you at the house and you're asking people questions about what's going on, correct?
I didn't ask anyone questions at the house about what was going on, sir.
And the Asian neighbor, Mr. Yoon,
Mm-hmm.
you talked to him?
I did not talk to him.
You never talked to him?
I did not.
You were not aware that he's identified somebody that's 6 foot as the possible culprit, the last person that saw Ms. Purcell alive?
I'm aware of what he did, but I did not speak with him myself
Why didn't you speak with him?
because there were other officers
But
investigating.
you're the
multiple-
officer in charge.
I understand that.
And this is your case,
Correct.
right? And so you're ultimately responsible for tabulating all the information, correct?
Mhm.
And presenting it to the prosecutor's office.
Yes, sir.
And you had a witness that you weren't aware of that identified someone other than Mr. Smith?
Objection, Your Honor. The witness did not testify. He wasn't aware of Mr. Yoon. He was asked whether he spoke with him, and now he's being belittled for not speaking with him.
Oh, Your Honor, no one's trying to belittle him. I'm cross-examining.
Hold on, sustain. Next question.
Did you ever take Mr. Yoon to a lineup?
Did I know?
Whose responsibility was that? To see if he can identify the person that did it.
He told us he couldn't identify the person that didn't, so we didn't conduct a lineup.
But he gave you a description and he told you that the man was 6 foot tall?
He said he was tall, as far
6
as I
foot
know.
tall?
I'm aware. He didn't tell me anything.
Oh, okay. You didn't show him a photo lineup?
No,
Why not?
because he said he couldn't identify the person.
So if a person say I can't identify someone, but I'm giving you a physical description, you're satisfied with not pursuing that any further?
Yes, if he says he could not identify someone, I'm
Okay. And you didn't try to get him to come in?
no.
Because you were convinced whatever Jaylen told you was the truth. Obviously. Whatever
not sure the
Jaylen
relation
told
there.
you is the truth.
What's that? I did not speak to Jaylen at any point.
Whatever Jaylen told the officers that had interrogated him, you had accepted that as truth, and that established your theory to this case.
No, not everything he told us.
Okay. What about the trail of fluid that led from the scene to the house? Oil, was it oil?
It was fluid.
It was fluid. What kind of fluid?
Vehicle fluid.
Vehicle fluid. And where did it lead to?
Multiple locations.
Ultimately, where did it come to rest? Jaylen's house?
I can't give a timeline of where and when the vehicle started and stopped. It ultimately came to rest where the vehicle was set on fire.
Okay. And that's right behind Jaylen's house, correct?
Not right behind, no.
I mean, you can have access from there to Jaylen Street, correct?
From the car to Jaylen Street, I'm not certain of that.
Can you get to Jaylen Street from the school?
Not directly, no.
But you can get there, can't you?
Yes.
Okay. How many pair of gym shoes did you take from that home?
I didn't take any gym
Well,
shoes.
personally, then you didn't take any. How many were seized from the home?
As far as I'm aware, 3.
3 pair of gym shoes? And what were they?
There was a pair of Pumas, a pair of Nikes, and a pair of Pradas.
Okay. And is it fair to say you don't know who was wearing those Pradas at the time? I'm strike that earlier that evening, in between the time that you suspected this crime occurred.
No.
You don't know if Jaylen and Mr. Smith has ever transferred shoes, do you?
Yes, I do know that.
Do you know that? Why? Because Jaylen told you?
No, Jaylen did not tell me anything.
Okay. How do you know they don't transfer shoes? Since you know that. How do you know that?
Your client told me he was wearing his shoes.
I'm saying, but transfer. Did you ever ask him, did you ever let Jaylen wear your shoes that evening? Did you ask him that
I
question?
didn't ask him that.
So how do you know he didn't have them on when this incident occurred? Why didn't you ask him?
Because I don't believe that was relevant to my investigation.
It's not irrelevant who was wearing the shoes, and you're using that as the basis to establish who the person was allegedly responsible for the crime? You didn't think that was a necessary question?
I'm sorry, you're going to have to ask me that again.
You didn't think that was a necessary question to find out if he had lent his shoes or they had traded shoes that evening?
I asked him what shoes he was wearing throughout the evening. I'd never asked him if he traded shoes with Jaylen.
Okay. You didn't give him a specific time.
I did.
You say at the time of the incident, you said, were you wearing those shoes? And he said, yeah.
Well, he denied knowing about any incident, so it was hard to ask him what he was
You,
wearing.
you said you gave him a timeline. Did you tell him, hey, at 11:30 in the evening, or did you let Jaylen wear your shoes?
It wasn't an exact timeline. I couldn't
Well,
establish
that's what you
was
testified to. You said, I gave him a timeline. Now you say it wasn't a timeline?
happening. I said it was a general timeline.
Okay, well, you're investigating a homicide, correct?
Correct.
You think you have the person that you believe is responsible, correct?
Correct.
You didn't want to ask a specific question as to when he wore those shoes?
I did.
Well, what did he say?
He didn't know an exact time as to when he even arrived at Jaylen's house, so it was hard to get an exact time of when he was wearing the shoes. I was able to relate them to events.
Okay, so the answer to the question is that you don't know if Jaylen had on the other shoes that you identified as being my client's shoes. Is that correct? You never asked that question.
I did not ask that question.
And so, and the basis of your investigation has been established by Jaylen speaking to you first about what occurred, correct?
No, the base of my investigation has been upon evidence.
That's your theory, right? That
No, it's evidence.
Jaylen created the framework, right?
Jaylen gave us some information in a large investigation.
Does Jaylen own a two pair of strike that. You said there were 3 pair of gym shoes that were taken out of that house.
Yes.
You said there was blue Nikes. Is that what you said? Did you find a pair of black Nikes?
I did not find a pair of black Nikes, no.
Did you know he owned a pair of black Nikes?
I'm not aware of that.
Okay. The clothing that were found inside of the wash machine. You said Jaylen told you those clothes belonged to Mr. Smith.
Yes. Well,
Now Jaylen's washing Mr. Smith's clothes? Is that what you're testifying to?
that's what I heard Jaylen state, yes.
He was washing somebody else's clothes.
Correct.
Did you ask Mr. Smith why Jaylen was washing his clothes?
Yes.
You spoke with someone at the 7-Eleven,
Yes.
correct? And you also watched a video of the 7-Eleven.
Yes.
You said that Jaylen got out of the car, is that correct?
I never saw a car.
You never saw a car?
No, I only saw the inside of the 7-Eleven, sir.
Okay. And so you don't know who was out in the car?
I don't know if there was a car
You don't know if there was a car. Why didn't you ask Jaylen?
because I never spoke with Jaylen.
You never spoke? I thought you said you had a chance to speak with Jaylen.
I never said that.
Never spoke with Jaylen.
No.
No further questions.
Mr. Smith?
Nikes and the Pradas are different sizes, aren't they?
Yes.
And when you're testifying about the footprints at the fire scene, you weren't saying that all the footprints in the entire area were walked away, were you?
Correct.
You were in the house when Jaylen was being questioned when he was in the kitchen? You were in the kitchen part of the time or
Yes,
all the time?
for some of it, not the entirety.
Which part?
Jaylen was still denying any knowledge of anyone in the home being involved in a homicide at that point.
You weren't there when he started giving the information?
Correct.
What time did you arrive at this Stringer house that first night?
It was sometime between 4 and 5 a.m.
And what time did the first arrivals of the police get there?
Maybe a half hour before myself.
Okay. And when were you at the 7-Eleven?
I was there on 2 occasions, I believe, just before I went to the Stringer residence and just after.
The clothes that Defendant Smith was wearing, what happened to them
Wearing at which point?
when you first came in?
I don't know what Defendant Smith was wearing when I first came in. He was not present.
Okay. He was already gone by the time you got there?
Correct.
Okay. As the officer in charge, do you know what happened to the clothing he was wearing when the first officers came in?
I believe they were taken as evidence.
And still in evidence?
Yes, nothing's been released.
And there's an inventory of that evidence?
Yes.
Do you recall whether the black latex gloves are included in that?
Yes.
You recall, and the answer is yes?
Yes.
Thanks.
Thank you. Ms. Collins?
You were asked whether you asked Mr. Smith who was wearing the shoes that night.
Yes.
Did you talk about the Prada shoes?
Yes.
Did Mr. Smith indicate whether or not he had worn those Prada shoes that night?
Yes.
And what did he tell you?
He stated that he wore the Prada shoes to Jaylen Stringer's residence. When he left the house, he said he put on a pair of Nikes. That was to go to the Kroger. He said he returned to the house, took off his Nikes, put his Prada shoes back on to go to 7-Eleven in the boat launch.
Okay. So in Mr. Smith's version of events, he conveniently wasn't wearing the Pradas when he went to Kroger and
I
supposedly...
object to mischaracterization that he conveniently.
Sustained.
In his version of the events, he specifically told you that he was not wearing the Pradas when he left for Kroger.
Yes, ma'am.
Okay.
I'm sorry, can you repeat that, please?
Certainly. In his version of the events, he specifically told you he was not wearing the Pradas when he left for Kroger.
Correct.
So you said he wore the Pradas to Jaylen's house and then left and put on Nikes? Is that what you said?
Yes, ma'am. He if I could repeat again.
Yes,
He
please.
said he arrived at Jaylen Stringer's house wearing a pair of Prada shoes that he owned. He said he took those shoes off, left the house to go to Kroger, was wearing a pair of Nike shoes, came back from Kroger, took off the Nike shoes. He and Jaylen then left for 7-Eleven in the boat launch, and he put his Prada shoes back on and wore those until they returned back to the residence on Shorecrest.
Thank you.
And I just want to make sure I'm following his version. So, did he claim then that he was wearing the Nikes when he met up with these persons and asked them for directions and then looked to the left down another street and saw lights and approached this woman in the car?
Yes.
Okay. Now, we've talked about the shoe prints in the Westover, in Ms. Pesserol's driveway. How many sets of footprints were located in the Westover driveway, in Ms. Pesserol's driveway?
1.
Okay. Which are bigger in size, the Nikes or the Pradas?
The Nikes.
Are they significantly bigger or just a little bit?
Several sizes.
Several sizes, okay. I have no further questions, Your Honor.
Thank you, Ms. Rhodes.
Say shoe prints. Now, I don't know, and maybe you correct me when you say several sizes.
Yes, sir.
Did you compare the shoes though? You're looking at numbers, right?
Right.
Prada comes in and it's like it's an Italian shoe. You have Italian size as opposed to American sizes. So when you say a bigger size, does that mean a bigger shoe or just a bigger size number? Isn't that correct? Larger size number. An Italian shoe may have a larger number, but it's a smaller shoe. American shoe may be to fit. 12 is a 12. So you're comparing an Italian shoe with an American shoe, correct?
If that's what you say, I'm not aware of that.
Well, you're saying that one was substantially bigger than the other, so what are you basing it on?
I'm saying the sizes were bigger.
Sizes as in numbers, right?
Correct.
Okay, so would you agree with me that sizes does not actually accurately reflect the actual fit of the shoe?
Yes.
So you don't know if Jaylen can wear those shoes or not, correct?
Well, given this,
Sir, you don't know, do you?
Yes.
Yes to what?
Yes, I do know they would not fit on his feet.
You put him on his foot?
I did not put them on his
You
foot.
didn't put him on his foot?
I did not put him on his foot.
You ever asked him if he ever worn those shoes?
I did not ask him.
Why
that.
not? Why didn't you ask him did he have those shoes on at night?
Because I never spoke to Jaylen Stringer, sir.
Why you could have stopped? You could have spoken to him.
I don't believe I could have.
Why not?
Because he was being interviewed by other detectives whenever I saw him, and after that fact, he had invoked his right to an attorney.
Well, tell me now, who's Officer Hamilton?
Detective Hamilton?
Detective Hamilton.
He's a fellow detective with West Bloomfield Police Department.
You had an opportunity to read his report, correct?
Not all of it, I believe, is still active.
What do you mean, not all of it?
He's made adjustments to the report that have not been finalized yet. That I
He's
have
still
not checked.
making adjustments?
Yes, he's adding to it.
He's adding to his report?
Yes.
So if it's information that he hasn't provided us is going to appear after we finish this exam?
Yes, because he's still actively investigating.
Okay, well, how about 12/10/2016, approximately 5:20? You recall him preparing a report?
Yes.
Okay, and in that report, you recall reading that Jaylen went outside and left the home with his lawyer and sat and talked in the car with his lawyer?
I don't recall reading
Let me
that.
see if we refresh your memory. On page 272, Thomas Randolph also arrived at the home where he and Jaylen went outside to his vehicle to speak.
Yes, that was why we were conducting the search warrant.
Okay, that's what I'm saying. This was before you talked to Jaylen, correct?
I never spoke with Jaylen,
I mean,
sir.
just before anybody spoke to Jaylen.
No, that was well after.
Oh, okay. What date did that happen?
What day would what happened?
When the lawyer took him out of the house and was talking to him.
I don't recall. It was the next day or later that same morning.
Okay. Was that before or after Jaylen made his statement?
After.
Okay. No further questions.
Thank you, Mr. Smith.
Nothing further.
All right, thank you very much, Detective. You can sit down.
Thank you.
You're just confirming that I have admitted People's Exhibits 1 through 17.
Yes.
Thank you. Your Honor, I have no further witnesses. People rest.
All right, Mr. Evans, will the defense be calling any witnesses?
No, not at this time, Your Honor.
All right, Mr. Smith, will the defense be calling any witnesses?
No, Your Honor.
Okay, Ms. Collins, go ahead with your bind over. I want you to please focus on the elements on the counts.
Thank you. Yes, Your Honor. I guess I'll start by indicating that Mr. Smith is charged with 3 separate counts. He's charged with open homicide or open murder. He's also charged with possession of a firearm and the commission of a felony, and he's charged with 4th-degree arson. Mr. Stringer stands before you charged with tampering with evidence in a criminal case punishable by more than 10 years and with accessory after the fact to a felony. Focusing in on initially the homicide, that Ms. Pesserel died at the hands of another by some act of criminality. You heard from Dr. Packris that the cause and manner of death are a gunshot wound of the abdomen and that the manner is homicide. That she was shot to death using a firearm, that would be what that indicates, and that a bullet was recovered in her L2 in her body as a result of or during the course of the autopsy. We also know that her body was placed in a car and the car was lit on fire in order to attempt to hide the evidence of the crime. An argument can be made. It's obvious that she died at the hands of another, and the question is whether or not there's probable cause to believe that Mr. Smith did it. What we have here, and this relates to all 3 of the counts, the arson as well as the homicide as well as the felony firearm. What we have here are a number of different locations that conspicuously contain the same set of shoe prints at all of these locations. What we know is that DeSean Smith was at several of these locations by his own admission, and the shoe prints match his shoes, Pradas, that he acknowledges wearing that day or that evening, and bringing to the table, if you will, wearing them to the Stringer home when he arrived at the Stringer home. First, you have the arson that's committed at behind Pine Lake Elementary School. We heard from Byron Turnquist, the fire investigator. He indicated that he ruled out accidental causes, that there were 2 different locations, primarily in the front of the car as well as in the trunk area, where an ignitable or an accelerant was utilized, gasoline, in order to light the car on fire. He ruled out accidental causes and ruled that it was incendiary in nature, meaning that it was a man-made or human intentional fire placed on that car. He talked about the evidence that was obtained, and we also have evidence that there was gasoline found in different areas at the front of the car as well as in the back of the car in the trunk area, specifically on items that were located underneath where Diana Pesserol's body was. With regard to the prints that are shown there, we know we have tire tracks leading from Wimberley Court area through the yard of Mr. Felon across from Mr. Yoon up into the field, and those tracks follow and lead directly up into and where they come to rest where the car is on the blacktop of the basketball courts. Leading away from that location, Officer Mentan testified that when he arrived on the scene, he was the first to arrive, and the sole set of footprints that were there were leading away from the car fire. He observed them. While many of those right around the car may have been washed away once the firefighters came to extinguish the fire, Officer Mentan was very clear that he saw no other disturbances other than the tire tracks leading to the vehicle, as well as the footprints leading, shoe prints leading away from the burning vehicle. Those shoe prints were photographed and were preserved in order to preserve what they could while still putting out the fire. Those footprints or those shoe prints led away from the arson and led toward Wimberley Court. You heard that there was that single set of shoe prints. No other person wearing shoes walked away from that location. That's what the evidence reveals. You also heard from Mr. Yoon, who lives on Wimberley Court, about what he saw earlier, prior to the fire occurring. We know that from the times of the dispatch and from the times of the response. What he indicated to the police and what he indicated during his testimony. And while he's calling into question his ability to recollect accurately, and he talked about or testified about talking to several different people, he acknowledged both on direct and on cross, and maintained specifically when he was being cross-examined, that he truly believes that he heard a female screaming. What he saw from his home, looking out through the window, was a figure that he believed to be a female, still heard the screaming, running away from that car. You have unidentifiable heel prints, that was testified to by, I believe, Officer Jacob, that are consistent with another person running away, but it would also be consistent with someone who is not wearing shoes, who is in either stocking feet, wearing socks, or bare feet. And we know from the autopsy report that has been put into evidence that the victim, Diana Pesserol, was found wearing only socks. You also have another single set of shoe prints. Those, again, very similar, and they match the Prada shoes that have been taken into evidence and that have been acknowledged by Mr. Smith as being his. And those, you had footprints, or shoe prints, I apologize, shoe prints that are consistent with someone being there at the same time as the woman who's screaming and running away. It's the people's position that that's Diana Pesserol, and she is running from her vehicle at that time. You heard from Mr. Yoon that he can't identify specifically the car, but that it was a sedan. You also heard that there is a figure walking back a short time later, gets in the car, and when there's a flashlight from the neighbor across the street, that car takes off in reverse, pulls up onto the lawn, and then proceeds back toward where Shorecrest is. Mr. Yoon said he cannot testify whether that car turned or went straight. He couldn't see it once it got to Shorecrest, but we know from the map and from the descriptions of all the officers that Shorecrest is that very next street there. We also know from Officer Jacob that in addition to the tire tracks that are consistent with what Mr. Yoon said, and the shoe prints and the heel prints in that area, we also know that Officer Jacob detected damage to the wood barrier at the end of that dead end, as well as a fluid trail that is consistent and follows along with those tire tracks that Officer Jacob observed. And what Officer Jacob tells us is that those tire tracks and that fluid trail leave, they go up onto the lawn, and they go back down toward Shorecrest. And at that time, they go off in two different directions. And he testified about how he followed those fluid trails back to Westover and also to Shorecrest. And he followed first to Westover and was able to follow the fluid trail over there, which indicated that the car had traveled back to Westover at some point, leaving the trail and the tire tracks, as well as at some point going to Shorecrest. Which again, there's a connection with Mr. Smith to all of these locations. We know that there's a connection with Mr. Smith to the location at Westover Drive and to the driveway of Ms. Pesserol, because Mr. Smith told Detective Case about his jaunt to Kroger. And he told him that he went to Kroger. He told him that when he got lost, he encountered some residents over on A Street, which is corroborated by Quinn Kiriakis' testimony about how a male came and asked for directions. She testified that she asked him if he was looking for Mr. Stringer's house, and he said yes, which indicates, Your Honor, that it's not Mr. Stringer who is out there on the street. She indicated that she was familiar with Mr. Stringer, and this person asked her how to get to Shorecrest, and she's the one who asked him about Mr. Stringer's house. And he acknowledged that, yes, that's where he was trying to get back to. Again, consistent with what he told Detective Case. He also, Mr. Smith indicates to Detective Case that when he followed the directions and the path that he took, and when you coincide that with the map and the path that he claims that he took, turning left onto McNichol Trail, and then he's supposed to take another left, but when he feels like he missed the street and he turns back around, and now he's heading back the way he came, back toward Iverness, and he looks to his left. To his left, Your Honor, is consistent with that is Westover Drive, and he sees a car that's running, and he sees a light, and he proceeds down there. And what is significant about that, Your Honor, is that the only set of shoe prints in Ms. Pesserol's driveway are the ones that are consistent with the Pradas that Mr. Smith acknowledged wearing to Mr. Stringer's home. Now, one must ask the question about why he denies or why he gives a different description of a woman unless he knows that that's the person who was murdered. Why he conveniently is not wearing his Prada shoes when he tells his version of the events to Detective Case, and he knows exactly when he shouldn't be wearing them. And that is because it raises a question of fact at the very least, that he knows when this homicide was committed, and he knows what he's got to distance himself from when he's speaking with Detective Case. All of that gives rise to, at the very least, a question of fact as to whether or not he was the one who committed the homicide on Diana Pesserol. Your Honor, as it relates to the arson itself, we talked about a stipulation as to the value of the car, that it was over $1,000, and we know that it was an arson that was committed. We also have evidence that there was gasoline on those Prada shoes, which also places those Prada shoes at the scene of where gasoline was utilized. And again,
Now,
with all...
Jack, there was no evidence presented that there was gasoline found on those shoes.
I have my notes, and I'm pretty sure there was some type of substance accelerant that was placed on that was discovered on the shoes.
It was, Your Honor, and I do believe it is in one of the lab reports that has been admitted into evidence.
Go ahead.
With regard to, and there's gasoline found on the Prada shoes, again, which places those Prada shoes at the scene of the arson and those Prada shoes at all of the other locations, including the boat launch, including minutes after he went to 7-Eleven with Mr. Stringer, and they were stopped by Officer Daly, conspicuously at a boat launch at roughly 1:45 in the morning, shortly after this homicide has occurred and officers are responding to the scene of the fire. As it relates to the felony firearm, there was a murder that was committed and a firearm was utilized. Again, all of the evidence points to Mr. Smith as the person who perpetrated the homicide of Diana Pesserol, as well as possessing the firearm at the time and beginning the fire. They're on the gasoline, the accelerant is found on his item of clothing, his shoes. The shoe prints are found at all the different locations where witnesses corroborate seeing incidents or seeing different pieces of information, providing different pieces of information, and placing the victim at these different locations. We have Ms. Nager who last saw her and sitting in her driveway at 10:40 a.m., and we have a window of when this occurred. The people submit that there is a question of fact as it relates to all three of the counts levied against Mr. Smith. As it relates to Mr. Stringer, when we're talking about accessory after the fact to a felony and tampering with evidence, what we know is all of the evidence that has been presented with regard to him having DeSean Smith, his friend, over at his home that night, what he told the police about where he was and what he was doing. But what we do know, and what is significant as it relates to these charges, is that he told Detective Kassab, and Detective Case testified to this. First of all, Mr. Stringer testified that he and his father were playing Madden football on the television. And during the second game, at some point, Mr. Smith left. And when he returned, he told him he needed to talk to him about something. And they went upstairs, and what Mr. Stringer told Detective Kassab is that Detective Smith opened his jacket, showed him the butt of a gun, and said, "Bitch grabbed my gun, I had to shoot her." What we also know is that when he's talking to Detective Kassab in the kitchen and Detective Case is there, Detective Case testified that that Mr. Stringer indicated that he washed DeSean Smith's clothes when they got back from the 7-Eleven. We know he already knew about DeSean Smith shooting someone when he placed those clothes in the washing machine. So that's number one. That's a way of tampering with the evidence, trying to conceal or get rid of evidence by washing away any evidence that's on Mr. Smith's clothes. We also know that Mr. Stringer did not call the police. He did not alert anybody to the fact that his friend had shot somebody. And that's the information that he provided to the police that he knew at that time. We also know that his fingerprints are found on the bag containing the revolver. He indicates to the police where Mr. Smith hid it, but we also know that there's a suggestion that Mr. Stringer aided in or assisted the defendant, Mr. Smith, in concealing that item because his fingerprints are on the bag. I would reserve any further argument for rebuttal, Your Honor, but it's the people's position that there is a question of fact as to each and every one of these charges, the 2 levied against Mr. Stringer and the 3 levied against Mr. Smith.
Thank you. Mr. Evans.
Your Honor, briefly, as it relates to Mr. Smith, Your Honor, it's clear that Mr. Yoon saw somebody. So I believe he's the last person to see the complaint alive. He was out, he saw what occurred, he identified the person as having long hair below the earlobes, also being approximately 6 foot tall. Clearly, Your Honor, that's not my client. Clearly, that's not my client. And the prosecution's theory is that allegedly my client had done the crime because of a pair of gym shoes that were found at the home of the Stringers that were provided by Jaylen Stringer. Also, Your Honor, as it relates to the credibility of the information that was provided by witnesses and law enforcement, Your Honor, it appears that Jaylen's father initiated communication, and he was involved in the interrogation. He coached his son, according to the officer, to prompt him in order to talk to the police after Jaylen was threatened that he can either be a witness or he can be a suspect. He comes out with a story which allegedly points the finger at the co-defendant. Your Honor, we believe that there's some serious issues, especially in light of the fact that Mr. Yoon has identified someone other than Mr. Smith. No way that Mr. Smith can be perceived to be 6 foot tall. The person who was out there that night was 6 foot tall. He was a taller young man. Your Honor, the information that they're relying on is a pair of gym shoes. There's no evidence on the record that could corroborate the position by the prosecution that my client was wearing those shoes at the time. There's nothing to suggest that he was wearing those gym shoes at the time of the event. They took his statement. He voluntarily talked to the police. He informed them that he had been in the neighborhood, but yet still, Your Honor, at no point did he concede or no point was it asked, was he wearing the shoes at the time? Officer testified that there was a timeline. Now he says a general timeline. But he had an opportunity to ask him, were you wearing it at this particular time? The question was never posed to him, Your Honor. Again, there was nothing other than information that's provided by the co-defendant, which is used to establish probable cause that my client is responsible for the crime that's set forth in the complaint warrant. We believe, Your Honor, that this matter should be dismissed because this court has the option to consider the credibility of all the witnesses. And it appears, it's apparent, Your Honor, that the prosecution is relying on the information that's been provided by the co-defendant that has been prompted by his father, who was obviously deeply involved in the investigation and also the interrogation.
Thank you, Mr. Evans. Mr. Smith.
Thank you, Your Honor. I'm not sure if I was listening to the same proceeding that he was. I'll rely on Ms. Collins as far as all the evidence of the person who was out on the street walking around clearly points to Defendant Smith. Mr. Evans said that there's no evidence that the shoe prints establish everything. I think every witness out there established.
So is he arguing for his case or is he arguing against me? I think his obligation is to
He can make his
refer to the
closing
prosecution,
argument.
not me.
He can make his
Not
closing
the
argument. Why don't you
prosecutor.
just reference your client, Mr. Smith?
Your Honor, the crimes that he's accused of are specific intent crimes. I've reviewed the tapes of the first part of this hearing and listening here today. I don't think there was any evidence that established when Jaylen knew about the crimes. And the criminal jury instruction for accessory after the fact, part 2, the third item, he has to have known that the other person had committed a felony. I don't think there has been any evidence that he knew of the crimes when he washed the clothes or was involved with the gun. Detective Kassab, when I asked him, did he know the time, or in the pure sense of time, or did he know the time in relation to an event? And his answer was no to both of those. So there was no evidence from him that Jaylen knew at the time he washed the clothes or was involved in the gun that a crime had been committed. And no witness at the prior hearing, because I've watched it about 4 times, testified and Ms. Collins did not provide any other form of evidence that indicated when he knew of the crimes and that occurred before he committed the acts that they say he committed.
Thank you very much, Mr. Smith. The testimony started the last time we were here with Dr. Bernardino Pacris, who testified he's a deputy medical examiner in Oakland County, that his duty is to conduct autopsies. He is a doctor of medicine licensed to practice in Michigan. He gave his background credentials. He was qualified as an expert, and he said that he conducted an autopsy on Diana Pesserell on December 9th. He testified that the body was charred and had 3rd to 4th degree burns, and that there were bone fractures, skin splitting, organs. And he did an external and an internal exam. There was a hole in the abdomen. The bullet was L2 vertebrae, perforated stomach, a large bullet in the second lumbar. He opined that the shooter would have been taller than the victim or would have been standing above because the trajectory went downward. He stated that the abdominal aorta was almost destroyed and that she may have lived a couple of seconds. He categorized the manner of death as homicide. Officer Mendham testified he's been in law enforcement for 29 years with West Bloomfield. He was called to a fire at the old Pine Lake School on December 9th. He testified that the school's in pre-stages of demolition, that they have extra patrols in the area, and he was working the midnight shift, that he entered the property on the north side of the building, which is the main entrance, that the entrance has a barricade, approximately 4 barricades at the school, that there had been snowfall. On his first run over there, there was no footwear or tire impressions except his own. He testified later he was first on the scene. He came to the property again. He had passed by earlier at 12:37, no disturbances in the snow except for his. He testified from Long Lake Road, the fire was illuminating the trees. He drove onto the playground and saw a car engulfed in flames. It was on the south side of the property near the basketball court. That he observed tire and footwear impressions, that the nose of the car was facing east as if coming from a subdivision. He observed tire tracks and again footwear impressions. The tracks from the car went west-east to subdivision Shorecrest and Wimberley. He said the footwear impressions were from the car to the sidewalk. He called for his assistance. The fire was extinguished. The doors were closed at the time. When the trunk was open, they discovered a body inside. Crime scene tape was administered. Supervisor was called. The plate was run. When he was first there, he talked about when he went into the property. He used a spotlight circled around on his first visit. And again, there were no disturbances in the snow. He talked about where the car was on the west side next to the swing sets. And on Cross, I believe he itemized the time. The second visit that he made to the school was around 1:30 a.m., the first one at 12:37. He said there was one path from the car to the subdivision, that the footprints came from the rear of the car. He couldn't get close enough to the car. There was about a couple of inches of snow. That the fire department, when putting out the fire, disturbed immediate prints around the car, but that you could see the other ones. Byron Turnquist is fire marshal in West Bloomfield. He's trained in arson investigations. He was also qualified as an expert. He testified that he did appear to the scene, observed a car which was heavily burned. The police taped off the area and photographed the scene, the ground around the car. He testified that he also observed footprints and tire tracks on the snow leading to the basketball court, that the tracks from the snow were made from the car. He took photos of the car. He could not tell the color, make, or model of the car because of the heavy fire damage. At that point, he knew that human remains were found in the car. He took samples for accelerants from fire debris near the driver's side tire, the floor of the driver's side, the fire debris driver's side backseat floor area, and the clothing underneath where the body was. On December 12th, he collected more evidence: the passenger floor front, the floor passenger back seat, and a portion of the spare tire cover in the trunk. The cause of fire, he testified, was a human act. Gas spread in the vehicle and ignited. It was difficult to pinpoint where it originated, but he said that the tire and the trunk were positive for accelerants. On Cross, he itemized who else was at the scene, that he arrived on the scene after 2 a.m. The scene was taped off, that he observed the footprints, that he did not photograph them. He testified it was in the area of the bike path. The snow, he also testified that there was not very much, that he collected the samples and they went to the lab in Sterling Heights. And he also observed a set of footprints leading away. Officer Daly testified that she was on duty on December 9th, works for West Bloomfield Police. She was traveling on Pontiac Trail going east towards Orchard Lake, going to do a perimeter check at the school. En route, she saw a car at the boat launch in Orchard Lake on the west side. She testified that the car was facing the lake with both doors open and 2 subjects there. She testified the boat launch is less than a mile away from the school. It was approximately 2 a.m., cold, the doors were open. She turned her car around to see what the individuals were doing. She testified that they were standing closer to the car, but when she started to pull in, the car was now trying to back out. She put the spotlight on them and identified the driver as Jaylen Stringer. The passenger seat front individual was DeSean Smith. She testified that she considered the whole situation odd, that defendant Stringer, his demeanor appeared nervous, that he wanted to leave and he was slightly hurried, that Jaylen was more talkative. She had received information about the fire around the same time. She radioed in that where she was, that DeSean Smith said Jaylen had to use the bathroom. And Jaylen agreed, and then Jaylen said DeSean wanted to show him. Jaylen said that DeSean wanted to show him the lake. She testified that she noticed the footwear tracks. Again, she felt it was odd, so she took pictures of the tracks, understanding that this location was quite close to the fire at the school. She took pictures of the tire print and a shoe print. She said she sent the boat launch pictures to officers at the scene who were at Long Lake and Short Crest holding perimeter there. She said that there was one set of footprints on each side of the car, that she took pictures of each set of prints on each side. Again, more conversation. Jaylen said they got there, had to use the bathroom. They were both speaking for each other. She did not ask to search the car, did not see anything in plain view, did not ask to look in the trunk, did not touch the hood of the car, did not pat down the individuals. She said there was one specific type of footwear on the passenger side and another specific type of shoe impression at the driver's side. The car was registered to Jaylen Stringer. She said that the prints may have been overlapping at the scene, but they were both on each side. Again, she took pictures of the impressions. It was hard to take pictures in the grassy area by the lake. She tried but could not. She did not take pictures of defendant's shoes. She said there was enough snow to see the impression. Mr. Yoon testified that he lives at 3454 Wimberley Court in West Bloomfield, and on December 9th, he heard a long honking sound. He's testified that he was awakened, that the area where he lives is very quiet because it's a dead end. He usually goes to bed around midnight and heard the horn 30 to 40 minutes later. There was some unclarity in his testimony. He said that he slept in the study room, that he looked outside the window, faced Wimberley, and saw a car on the road heading to the dead end. He said it was 15 meters away from the dead end. There was a wood piece there, that the driver's side door was open and the interior light was on. 10 minutes later, a guy walked from the other side of Wimberley Court near Short Crest, went to the car and got in on the driver's side. Then he saw his neighbor use a flashlight or a spotlight. He said it was too dark to see. On the other hand, he said he observed an individual who was tall with long hair, a man, who was wearing a jacket, that the car went in reverse and over his yard and grass and drove out towards Short Crest. That he heard a sound of someone screaming. It seemed like a female voice. He said the pitch was higher, and that he told the police this information. He was questioned heavily on his memory. He acknowledged his memory would have been fresher at the time back then. So he described it as a horn, a scream, and someone running from the car. He testified that after speaking to a neighbor and his wife, he found that maybe his memory was not correct. So again, he was questioned when he spoke to police at 9 to 10 in the morning if his memory would have been greater then. He acknowledged that it would have been. He testified he did not compare notes with his wife or neighbor, that he told police that there was a female screaming and running from the car, that he saw a male coming back to the car and get in the driver's seat, and that the individual had long hair. Too dark to see, he said. Hair was underneath the earlobe. The man had his hands in his pocket, maybe 6 feet or taller. Next day he learned of the homicide. At one point he said he could not recall a lot, that his wife came to the room to wake him up when he had said he had awoken by the sound earlier. He said after the car left he went back to sleep. Officer Jacob testified that he's been with West Bloomfield Police. As an evidence tech, he was called to the Pine Lake School for a fire investigation, took photos, scale measurements. He said he went back to where the basketball courts were, observed that a car was charred there. The driver's doors were open. He met with officers and a detective, photographed the car, And the path to the wooded area, the the tire tracks coming off the blacktop onto the path. He said that the path goes through a wooded area, that the tracks were covered to protect the tracks, only one set of footprints that lead down that path. He said that the footprints were leading away from the blacktop area at the play set, that there were no other footprints leading away. And from there he went to Wimberley Place or Wimberley Court. He said that the footwear on the north side of the road leading away 100% matched the prints on the path leading away. On the south side of Wimberley, he testified it was snowing that night, that the foot impressions again were going west towards Shorecrest, that he went to the boat launch and met with officers on the outside, that they were not disturbing the area where the car was, that the exact same footprint and tread pattern as that at the school was there at the boat launch and Wimberley. Victim's residence is 4138 West Over. Testified, you could see that there was a car in the driveway from the snow, that he saw one set of tread and pattern in that driveway. The tread wear came from Westover, up the driveway, south side parked, patterns overlapped, cut across to the passenger side, and also walked away from the driveway, traveled up and down the driveway, all consistently the same pattern. He testified he came into contact with Mr. Stringer, that he came into the home, this would have been 403 Shorecrest, and he was given a pair of shoes from the living room between the couches, and Jaylen Stringer handed them over, that the tread pattern matched the pattern at every location. He said that they were shoes that Mr. Smith was wearing. He testified that he recognized the heel of the shoe there, that 100% matches the tread pattern that he had been looking at. The tire tracks on Westover 4138 came into the driveway, went off the road, and the next day he went back to Shorecrest and Wimberley. He said you could follow the tire impressions in the ground. There was also a fluid trail, a long trail of fluid. 3454 Wimberley, the fluid was leading into the front yard with a V pattern going forward to Shorecrest, north and south on Shorecrest, went south on Shorecrest, west on McNichol, and south and Westover into the driveway. The tire tread and the fluid led to 4031 Shorecrest, Jaylen Stringer's home. He testified when he arrived to the home, multiple people were there. Oakland County Sheriff's Department was there. That he was not an expert on tire tread, that he went to defendant Stringer's home to collect evidence. He acknowledged seeing more than one set of footprints at the boat launch. Again, he walked into the door and he was handed shoes. He had just come back from the police department, was there to secure the residence for a search warrant. His observations were that defendant Stringer went right to the shoes. He testified that defendant Stringer is taller than defendant Smith. The fluid was described as a brownish, reddish fluid on the path behind the school, Westover, and in front of Mr. Stringer's home. He also testified that the shoe that the shoes that were being discussed were Prada black male shoes with a rubber sole, and Detective Sergeant Gruenwald testified next, stated that he was at the home for Jaylen Stringer awaiting a search warrant, that he spoke to defendant Stringer at the home. Detective Kassab and Roy were there, that that Mr. Stringer told him that DeSean Smith came in from outside and needed his help. He opened his jacket coat, showed him his gun, and said, "I had to kill the bee." Jaylen said he was scared and didn't know what to do. He cooperated with law enforcement and directed him to the location of ammunition as well as the firearm. He said that 10.38 caliber bullets were in Jaylen's bedroom in a heat vent in a bag, that the bag was attached to a string within reaching distance. that a .38 caliber revolver, which was broken down in pieces, was in the living room in another vent, a floor vent, inside aluminum tubing. There was discussion about the laundry room, the Prada shoes, the bullets in the gun were taken into evidence. The gun again was broken into pieces, the handle, cylinder removed, all pieces disassembled and thrown into the bag. The garage, he indicated Mr. Stringer Sr. was very cooperative, that he showed him the car, located a lighter in the passenger side door, numerous gas cans surrounding the car, all empty. There were several, he said, approximately 5 gas cans on the driver's side door, one sitting on a shelf. The car, when pulled into the driveway, was pulled in at an angle going over landscaping. He said he got a call to go out to the home approximately at midnight. That at 5:49 a.m. he went back to the house, saw the tracks going across the lawn. That he talked to Jaylen one time at the residence, spoke with DeSean. That he also was there when Jaylen was spoken to in the kitchen for about 15 minutes and voluntarily gave information. He recalled the shoes being handed over. He testified that Miranda rights were not given at that time as he was not in custody. That Jaylen was a witness at this point. That he found him credible, that he was not hostile, and the conversation was voluntary. The father was telling him to be honest and to tell the truth. Karen Dutcher from MSP testified. She works at the Sterling Heights Crime Lab. She talked about the prints. She works in a latent print unit. She's been there for 27 years, 25 in the crime lab, and she processed latent prints on the gun. She said that there were known and unknown impressions. She processes and then compares them to known prints. 4 IDs were made, 4 latent prints for Jaylen Stringer from this bag. This was the bag that contained the firearm. She said the evidence was submitted from West Bloomfield Police. On December 9th, she received 6 gas cans, a clear plastic bag, and January 11th, a revolver and another gas can. No latent prints on the gas can. On the revolver, no ridge structure. Same thing for gas cans. On the bag, she said, I believe there were prints on the bag. She also said, in terms of lack of prints, it's possible to touch something but not leave a print. Erin Coho from the MSP Crime Lab also talked about trace evidence, fibers, and footwear, looking for ignitable fluid. She testified that she tested the air that was inside the bag. Each sample is a nylon bag. You place charcoal inside and you test the charcoal for accelerants. She testified the athletic shoes, these are the Prada shoes, that she found gas on the black athletic shoes. Quinn Kuryakos McBuchan testified she lives in Iverness, had friends over. This was December 9th. The attached garage was open. They were smoking in the garage when a man walked down the street asking for directions. She could not identify or recognize the individual. She said it was a black man. She responded to turn left and then left at the next street, and she texted Jaylen saying, hey, someone is looking for your house. This is 11:30 p.m. Shannon Nager testified that she lived right next door to Diana Pesserol, that at 10:40 she arrived home on December 8th and saw her sitting in her car as usual. Her car was on, and she was in the car. She testified that it was normal to see her sitting in the car. Her car was facing the garage, and when her niece left, she went inside. Her niece went out to the car. There was a stipulation as far as the value of the car. Is that correct? That was last week. There was a stipulation that there's value to the car. There's a stipulation today
That is correct, yeah.
All right, thank you. And I assume, Mr. Smith, that was yours as well?
Yes, sir.
Okay, so there was a stipulation today that the body is identified as Diana Pesserol, and the autopsy was of her. Detective Kassab testified that he's been in law enforcement for 13 years. He was present at the home of Jaylen Stringer. He identified him. He was there to speak to him on December 9th, middle of the night, 3 to 4 a.m. He said he was advised to go there by his supervisor. He entered the home and saw DeSean talking to Sergeant, I assume, Gruenwald in the dining room, and he saw Jaylen in the kitchen. He said he was there to gather information. He was sitting in the chair. The father was there as well, that he did not sequester the father. He was there while he spoke to Jaylen. Lieutenant Roy, Detective Case, Detective Tash were all present gathering information. Defendant Stringer was not arrested, and he agreed to speak to him. He said initially he was not so forthcoming, and his father was telling him, if you know something, tell the police, that Jaylen had information about the weapon in the home and wanted to go to the police station to talk. And that there was clothing in the washing machine which belonged to DeSean. He testified that his observations of DeSean Smith was that he was wearing a tank top and shorts, and it was very cold outside. Jaylen told him, DeSean came over, they played, he played Madden football with his dad, and during the second game, DeSean had left and came back, and DeSean had to tell him something. Jaylen said they went upstairs, he opened his jacket with his pistol showing, and the bee tried to grab my gun. Nobody grabs my gun, so I shot her. After he told him that, Jaylen got upset and punched him a couple of times. Washing the clothes for DeSean was apparently a norm for him because he came over frequently and he slept over. That was also his statement about the clothes. He did go to the station. Our detective said he was not under arrest at the time. Again, the items in this backpack, Jaylen, were that it was in the heat vent in his bedroom, and later a firearm was discovered upon his disclosure in a heat vent, and Jaylen stating that defendant Smith was wearing the Prada shoes. Lots of discussion on cross-examination about whether Mr. Stringer was in custody or had spoken to an attorney. Detective is saying he was not in custody, that he was gathering information, that he knew about the boat launch incident, that he was not satisfied with Jaylen's initial answers, that he thought he was withholding that his first statement was that the gun was in a backpack, it was not there, but the ammunition was, and then he said a second location. Again, they did go to the police station. He said he was not in custody and not a suspect at that time. Lots of discussion about whether an attorney was at the scene. Detective Kassab was not aware of an attorney being at the scene. Detective Case testified that he's the detective assigned to this case. He was on call. He's been in law enforcement for 8.5 years. He also responded to the Pine Lake School on December 9th. That he was provided information about the footwear, saw the fluid travel, the tire tracks, the wooden barricade was damaged to the school, that he was familiar with the shoe prints, and the foot impressions, the shoe impressions, I should say, and that all impressions were similar except for those of the boat launch. He said that one set is consistent and there is a different one from the boat launch, that he recognized the shoe impression in the picture that was at multiple locations, behind Pine Lake, west on Wimberley, the victim's home on Westover, and from the boat launch, that he recognized that shoe impression. That's I've got these exhibits up here. The shoe impression, that he was initially at the home with other detectives, Kassab, Tash, Newlock himself, and Mr. Stringer Sr., that he was not present for the entirety of these conversations, that he came into the kitchen and heard some of it, that Jaylen had washed DeSean's clothes after they came back from 7-Eleven. Detective did go to 7-Eleven because he received information that they may have gone to 7-Eleven. And he observed surveillance both at Qdoba and at 7-Eleven. The Qdoba surveillance revealed both individuals there, and Jaylen wearing blue footwear, DeSean wearing black. The 7-Eleven video, that's at 1:44 a.m., Jaylen wearing blue footwear. More testimony about what was in the laundry, a jacket as well. He received word that Defendant Smith wanted to speak to him when Mr. Smith was in custody for an unrelated matter. So he said he did speak to Defendant Smith, that he advised him of his Miranda rights verbally, and that he wanted to waive those rights and speak to him. He told Detective that he had gotten a cab from Northland to Jaylen's house and met with Jaylen and his family before they went to Qdoba and Wendy's with Jaylen, and that they returned to the house, and then he went to Kroger by himself, that he got lost in the subdivision, and then went to 7-Eleven with Jaylen, and then the boat launch with Jaylen. He said he was outside the Kroger store in West Bloomfield sitting on a bench, and then he asked 3 people where Shorecrest was. This is consistent with the previous testimony of the individuals in the garage. That he went down to the street, left, turned another left, went down McNichol. I could be wrong on these streets here. But the next left is Shorecrest, that he saw a car with a light on, with a female inside of the car, and that he had interaction with her, asked her for a cigarette, she gave it to him, and then he followed her directions to go back to Shorecrest. Detective stated he gave a description of that woman which did not match Diana Pesserel's description. He asked him if he owns the Prada shoes, and he said he did own a pair, that everyone in West Bloomfield owns Prada, that the Pradas were at Jaylen's house, and Detective knew those were, I believe, in custody at some point. He testified that the blue Nikes worn by Jaylen, at least in those videos, the treads were not similar to the treads that were consistent throughout many of these areas that were testified to. That again, Defendant Smith gave a description of this woman. Multiple detectives canvassed the neighborhood, Westover, Wimberley, Shorecrest, Iverness, and no one came forward saying they had interaction with anyone on their street. He also acknowledged that he went to 7-Eleven and the boat launch. Quite a bit on cross-examination on Miranda rights, and the questions put forth to Mr. Smith. Mr. Smith, again, that he wore the Pradas to Jaylen's house, then left, put on Nikes, and came back and put the Pradas on again, and then they left for 7-Eleven in the boat launch, and he wore them till he returned home. That was also in Mr. Smith's statement to Detective. Again, prosecution's argument relies heavily on the shoes. The exhibits that I have up here are the autopsy protocol, the map, pictures of the car, and the lab reports. But if I testified to quite a bit of what was on the lab reports, so I'll go to these pictures. There are pictures here, exhibits of the tread in the snow. And There are pictures of the black Prada shoes. They have a very distinctive sole, these black Prada shoes. And looking at the prints in the snow, one could make a strong argument that they match very much the print in the snow. Very, very much testimony was given regarding this particular tread, and the fact that it was at every part of this entire investigation. The charges against Mr. Smith are count 1, homicide, open murder, and possession of a firearm in the commission of a felony. I certainly find, as well as 4th degree arson, I certainly find that there's probable cause to bind him over on all 3 counts. For Mr. Springer, the charges are count 4, tampering with evidence, and count 5, accessory after the fact to a felony. I do find probable cause based upon the evidence that was found, his fingerprints and his statements, as well as to what he knew, especially as early on as he knew that a homicide had occurred, and that the evidence was then tampered with. That would be the clothing in the laundry in the washing machine, as well as the gun, which was disassembled, and the bullets found in a separate place. And I will bind Mr. Stringer over as charged as well. Thank you all very, very much.
Thank you, Your Honor.